Yeah, we'll just keep stacking them.
You know, I'm not real steady.
State agency in Richmond. We're part of the legislative branch of government. We've existed since 2000. And if anybody was, I can't remember now, I can't remember if it was this year or last year now, I'm getting a little bit lost, but with the newspapers, they did a FOIA audit where they went around and asked people for records that were open public records, and they tested their compliance with that. And one of the big pieces of news from that was the sheriffs and law enforcement agencies had about a 50% compliance rate. And a lot of news articles were saying, this is horrible. You know, they only get it right half the time, and they get it wrong half the time. That's just unacceptable. Well, back in about 1998, they did a study that was about the same thing, and at that time, Virginia had a 16% compliance rate. As a result of that, they did a 2-year legislative study, they made changes to the law, and they created the FOIA Council, which is our organization. We don't enforce FOIA, and we don't investigate FOIA. We do try to help informally to mediate disputes if people have, you know, anything that can be worked out without going to court. We're happy to help do that. But our primary mission is training, stuff like this, what we're doing right now, answering questions, issuing advisory opinions, and putting out the educational materials that you have in your handouts. The office is basically myself and my boss, Maria Everett, who's executive director, and she's been there since the council started in 2000. She's also an attorney for general laws, and she couldn't be here today, so she asked me to convey her apologies for that. But basically, between the two of us, we answer roughly, I think it's a little over 1,600 to 1,700 questions a year that are informal over the phone or by email, and we issue, it varies anywhere from about 10 to, I think the biggest one year was about 50 advisory opinions that are formal, written up, published opinions on our website. Among the materials you've got, the most useful is this little thing right here, just because it's got our contact information. It gives you a little overview of the council. Then on the back, it's got phone numbers, fax numbers, and the email and the website. So anytime, you know, with today we've got about an hour and a half, 2 hours to go over things. There's no way to cover all of FOIA in that time, so we'll do the best we can to hit the highlights and important bits. But if you have questions, feel free to give us a call, send us an email at any time. That said, we're going to go into a little bit about public meetings and about public records. I just want to let you all know, if you have a question, feel free to raise your hand, shout it out. If I don't hear you, just say something, get my attention, however, say, hey, yo, over here, you know, that's fine. Let's see, start with, we talk about meetings in FOIA. I guess the first thing we got to ask is, what is a meeting under FOIA? How many people here are members of the community college board? Anyone? Okay, how many here are staff persons? Any faculty here as well? Are everybody staff, pretty much? Okay. When you get together for a staff meeting, is that a meeting under FOIA for your department? An administrative meeting? Is that a meeting for FOIA?
No, so let's say a town hall meeting is not covered by FOIA.
Well, what it is, FOIA says specifically in the definition of meetings that a gathering of employees is not considered a meeting subject to FOIA. So otherwise, you'd have to give 3 days of notice, you'd have to take minutes, you'd have to do all the things that the full public body has to do for every time 3 or more staff members or a quorum got together. So if 3 of you met in the break room and started talking about your business as you know, staff for the school, that would be a public meeting. You'd have to invite the public in. You'd have to open it to any student who wanted to hear it. Anybody from the community. Somebody drives out from Wise or comes down from Arlington, you'd have to let them in. If we had to do that for everything we do as staff people for government, because I'm government staff as well, we'd never get anything done. I mean, it's a simple idea that, you know, you've got to, sorry about that, it's my umbrella. Basically, with FOIA, you've got to have a balance where they say, you know, there's government's need to function. We've got to get things done. But then the public has a right to know what government's doing because it's their government. We are a government by and for the people and of the people. So part of the whole thing is kind of an overriding theme. Just keep in mind, FOIA really is democracy in action. It's how people know what the government's doing. That's the whole point. And when the rubber hits the road, that is FOIA. That's what it's about. For meetings, the full definition, I'm not going to read to you because I don't put you all to sleep too quickly, but it's basically, the idea is when 3 or more members of a public body or a quorum if less than 3 get together and they're discussing the public business of that public body. And the gathering of employees is specifically excluded, like I said, so staff meetings don't count. A board meeting of the community college board does count, always. You know, city councils, school board meetings, these are the kind of things we usually think of with public bodies, and those are the things that count. That said, how many people actually work on arranging the meetings and setting up the meetings for boards or committees of the board, anything like that? One? Okay. We'll go through this all pretty quick. Do you have specific questions about the meetings? Okay. But I'm going to hit the highlights and move on to records after that because everybody deals with public records. Meetings, you got to look, as well as the definition of meeting, you got to look at the definition of a public body. And the big thing to keep in mind is anytime a public body like the board itself sets up a committee to perform a delegated function or to advise the board somehow, that is also a public body. That committee in its own right is a public body with the same meeting requirements as any other public body. So they've again got to post notice of their meetings beforehand. They've got to take minutes when they handle a meeting, and it's got to be open to the public. Those are your basic meetings requirements. Let's see, with notice, basic idea is you post your notice 3 days, working days in advance of the meeting. Working day means you exclude a legal holiday, you exclude the weekend, you count every other day. So if you all actually work on a Saturday, that would be a working day, even though it's not a business day. So there is a little bit of difference there. At the same time, if the school has a snow day and the whole school is closed, that's not a working day, even if businesses are open. So keep in mind, there's a little bit of difference between a government working day and a business day. Notice has to contain 3 minimum things. It's got to have the time, the date, and the location of the meeting. That's pretty easy. Notice has to be posted, I believe, in 4 total locations. For everybody, there's 2 physical locations where it has to be posted. That's going to be the office of the clerk or the chief administrator, and in a public place where notices are regularly posted. So if you have a main bulletin board somewhere that you always put all the notices up, that's a good place, and then office of whoever is the clerk or the administrator for the body. The other places are for state public bodies. You have to post on the Commonwealth calendar, which you can get to through virginia.gov. You can find the Commonwealth calendar there if you're not familiar with it. You also have to post on your own website if you use one. That's pretty easy. Minutes, basic idea of minutes, you've got to have members absent, members present, recorded, summary of any matters deliberated, decided, or discussed, and record of any motions made, votes taken. Those are your basic minutes requirements. One thing to keep in mind is all minutes are open public records, including draft minutes. Audio tapes, videotapes of meetings are also open. Once minutes are approved, they also are still open. I mean, all minutes basically are open records. So the only exception to that really is for closed meetings. You do not have to take minutes. And if you do choose to take minutes, they don't have to be considered open records.
Okay, if they request for audio tape on the board meeting,
Yes.
what is the period of time for how, I mean, are they given 3, 5 days? How many days do they have to provide the requested?
For an audio tape, it'd be just like any other public record, and it would be 5 working days to respond to the request after the request is actually received. So if somebody gets you a request in today, and this is a little bit of public record stuff, and we'll go ahead and do it. You get the request today, Monday. Tomorrow is Tuesday, is the first working day to respond. Next Monday is actually the 5th working day because you don't count the weekend, and I don't believe there's any holidays between now and then. So it'd be, you have until Monday to put that response in the mail or send them off an email or whatever. It doesn't actually have to get in their hands because there could be a delay in the mail or something, but you have those 5 working days to answer the request. One other common question is, can people bring a videotape recorder or an audio recorder into your meeting if they want to? The answer is yes. Anybody's welcome to do that, and you can't tell them no. What you can do is tell them where to place it. For example, we have the camera here today. It's out of the way, so it's not blocking anyone's view. If someone walked in and said, hey, I want to tape this meeting, but I want to put my camera, boom, right here in front of the crowd. You can say, no, I'm sorry, you have to move it off to the side. But you can't tell them, no, you've got to move it out into the hall. Because that's effectively just saying no. You've got to, keep practicalities in mind when you do this. Agenda materials is another common topic. The basic rule is whenever you provide agenda materials to the members of the body, you also have to make 1 copy available for public inspection. So for example, if you have a Wednesday meeting and Monday night you send everything out by email, just make sure you have another copy ready in your office in case anyone wants to see it. Again, with that, the rule is for public inspection, which means you have to show it to them, but you still have 5 days to respond. You don't actually have to provide the public copies immediately. You still have those same 5 working days if someone makes a request. Yes?
Maybe I'm confused there. As a dean, we have monthly meetings,
Yes.
division meetings for our
Okay.
academic faculty and our staff. Is that considered a closed meeting or an open meeting? Or
If it's a faculty and staff meeting, that would not actually be a meeting subject to FOIA, since it's a gathering of employees. If it's a meeting with the board, for example, the board brings their open meeting requirements and that'll have to be open. But if it's just faculty and staff, that's not subject to FOIA, you can conduct it how you like. And actually, someone mentioned town hall meetings. The whole idea of a town hall meeting is that it's open to the public. So if it's not going to be open to the public, just don't call it a town hall meeting, because it isn't. I mean, but that's not a FOIA rule, that's just, what you call it. If you're going to have an open meeting and it doesn't have to be open, but you choose to make it so, it sounds like a town hall meeting. Okay. With agenda materials, again, the one exception to making that stuff available for public inspection is if it's exempt materials, and we'll talk about that with public records. But if, say you had to discuss a student disciplinary matter and you had materials that named the student, you wouldn't give that out normally. So if that was in your agenda materials, again, you could withhold that for public
What about
inspection.
surveys with the names in it? Is that, can you distribute that? Is that,
Depends on the subject of the survey and whose names are in it.
so let's say
If it's, are it student names or employee names?
employee names?
Employee names on a survey? Depending on what they're saying, I mean, it might be considered a personnel record, depending on what exactly it is, but if the survey's got the names out of it, that would be open. If it's got names in it, a personnel record isn't defined specifically in FOIA, but it says personnel records containing information concerning identifiable individuals may be withheld, except to the subject of the record. So for example, let's say you did an employee survey of what do you think are conditions at the school?
Okay, yes.
And we want to know, put your name on it, put your position, your title, how long have you worked here? All that kind of information, and then your opinions on this question, that question, the other. I mean, a lot of that obviously is personnel record type of information, and you would at least redact that out, if not withhold the record entirely. But if you had a redacted version that just said, we compiled this into statistical summaries, and let's say 80% of people said, hey, we've got a great set of classrooms here, but we really need a new air conditioning system. Just for example. If you had that kind of information and there's no names attached, that's open. That's definitely an open public record. With the names in there, you could at least redact out the identifying information, because that's a personnel record. Now, if it was about students, similar, but there's scholastic record exemption rather than personnel records, and there's also prohibitions, of course, under federal law with the FERPA, Family Educational Rights and Privacy Act. So with that, you're getting into a slightly different area. We'll go into that a little more when we do records. With meetings, one other big thing to keep in mind is when people vote at meetings, FOIA says you cannot vote by secret or written ballot. So faculty meeting, that's not subject to FOIA, you can vote how you want. Staff meeting, same thing, but when the board votes, they have to vote in an open meeting. They have to do it publicly and say what they're voting on. With closed meeting procedures, there's 2 basic things to keep in mind. It's going into a closed meeting and going out of a closed meeting. To go into a closed meeting, the first thing you've got to do is make a motion to close the meeting. So backing up a step, that means the first thing you've got to do actually is have an open meeting. You can't have a closed meeting without having an open meeting first, because with that motion, you've got to vote on your motion. And again, you cannot vote unless it's open. So I haven't seen this here, but it's something I've seen elsewhere. And just to warn you about it, some people like to have a closed session at 4 o'clock, and then we'll come out to open session for the public at 6 o'clock. Is that okay? Not that way, no. If you have an open session at 4 and you're immediately going to close it, that's fine. But you got to have that open session first so you can do your motion and your vote in public. The motion has to have 3 things in it. It's got to identify the subject of the meeting, the purpose of the meeting, and it's got to cite the law that allows you to close the meeting in the first place. Some common examples, personnel matters, if you're discussing personnel. There's one for student disciplinary matters, if you're discussing students. There's one for personal matters, if it's something that doesn't have to do with public business. Another common one is if people need to discuss something with their attorney, or if you're getting sued and you have to discuss that with your attorney, you've got a legal matters exemption. So those are all fairly commonly used, as well as some for negotiating contracts, which is a pretty common one. What we see a little bit too often, unfortunately, is a lot of people make motion where they say, we are going to go in for legal matters And we're doing it pursuant to 2.2-3711 sub A sub 7. And that's it for the motion. Now remember I said there have to be three elements. You gotta have subject, a purpose, and a site. That has a purpose, we're gonna discuss legal matters. It's got a site, 2.2-3711A7. What's missing? A subject. What are they going in there to talk about? I have no idea. So, the idea with subject, you've got to do more than just cite the law. It specifically says a general reference to the law or the statutes is not enough. So you got to do a little more than just cite it or quote it. But you don't have to do so much that you defeat the whole purpose for going into your closed session. So for example, one thing I've seen commonly is we're going to go in to closed session pursuant to 2.237A7, discuss legal matters with our attorney concerning Smith versus the college of whatever, or something like that, where they'll just name the case. That doesn't tell you really what they're talking about, the substance. It's not going to give up your legal position, but at least people know, oh, they're talking about the case. Okay, no problem. I understand why they're going into closed session. So that's one of the nods to government for function. When you have to discuss something sensitive, contract negotiations, legal matters, you're getting sued over something, a personnel matter, a disciplinary matter of a student, you can go into closed session to do it. So those are some of your purposes. Once you've made that motion, go into closed session. Again, as I mentioned, you do not have to take minutes in the closed session. If you choose to do so, they're not necessarily going to be an open record under FOIA. But keep in mind, if you get sued, they might still come out under a subpoena if you do choose to take minutes. When you come out of the closed meeting, though, you do have to certify that the only things you discussed were the things identified in the motion and allowed under FOIA. And there's a procedure, actually, if someone disagrees and says, I think we didn't do it right, I think we strayed from the topic we announced, or we strayed from what's allowed under FOIA, they're supposed to make an announcement of, this is how I feel about it, before a vote on the certification is taken, and that also gets entered into the minutes. With motions, they get entered into the minutes too. And the best idea is anytime you have a motion or a vote or anything like that, enter it verbatim, word for word. That way there's never any question about, well, they said they made this motion, but I don't know if they really made it right or not because it's not word for word in here. They just referred to it, so I don't know what they did.
Is that a requirement?
That's our advice. It says you shall set forth the motion in detail, which to me means word for word is the easiest way to do it in detail. You've already got it written out. You might as well just copy and paste it into the minutes. That's what I would do. Any questions on motions, certification of closed meetings, any of that? We've already talked about some of the basic general exemptions. There are a number of rules for electronic meetings of public bodies. Does the board ever meet electronically by people phoning in or having a conference call?
We've had requests from the media, posting.
To post things electronically? Yeah, that's a little separately than the meeting. I'm thinking of, if the board itself actually gets together by having, a quorum is physically in one place and then there's three members out in other places calling in.
What about?
Did they ever do that?
Phone conference call, is that considered as?
Yeah, that could be an electronic meeting if it's the board doing it, but again, faculty and staff aren't considered a meeting. So faculty and staff can go ahead and do that all they want to. With the board doing it, there's specific rules for holding the electronic meetings.
I'll ask you specific questions.
Okay.
Later on.
All right. If no one has specific questions and the board doesn't actually use it, I'd rather save our time.
Yeah.
Basically, we've run through all the meeting stuff really quick, just hitting the highlights. Does anybody have specific questions on holding a meeting, attending a meeting, anything like that? Okay. We'll go on to records. Everybody has public records. Does anybody here not work for the government, not work for a public body, not serve a public body of someone? Okay, everybody does. First thing to ask with public records, again, what is a public record? So, easiest way to do this is, try not to fall asleep, close your eyes. Think about your office, where you work. Think about what you've got there. Probably, some people have filing cabinets, computers, notepad, letters, inbox and outbox for mail, all that stuff, files on your computer, everything. What if that is and is not a public record?
All of that is public record.
All is a public record. Maybe. Let me ask you this. Did you ever bring a magazine into work? From home? Novel. Some people might have done that at some point in time.
A
Picture
business
of family.
magazine.
You ever have a picture of your family or friends and you put it up? plant, poster, decoration, artwork, is that stuff public record? Definition of a public record is going to be anything written or recorded in any physical format. It can be, notepad, it can be your computer, it can be if somebody writes a big important note on the back of a spare shirt. That can still become a public record. Audio, video, old cassette tapes, any type of record. Doesn't matter what physical medium it's on. If it is owned by, prepared by, or in the possession of a public body, its officers, employees, or agents in the transaction of public business. That's kind of the key terms there. They appear at the very end of the definition. It's got to be owned by, possessed by, prepared by, public body, employees, agents, officers, in the transaction of public business. And that phrase is not defined, but that phrase is pretty crucial, I think. There are some cases right now in Spotsylvania and Loudoun counties regarding boards of supervisors and emails where they're talking about just that. What is a public record question? The cases are on appeal, so I don't want to say too much about them. We have to wait and see what the judges say on there, but my understanding from the Loudoun County cases is a woman was interested in finding out who her supervisors had been talking to, and she felt they had been talking to some developers and ruled against her on a land use issue because of it. And so she wanted to know, who all are you talking to? She was asking for all their emails. They gave her some emails, they didn't give her all of them, because some of them they said were personal business. They weren't about public business, so I'm not going to give you those. At the general district court level, she sued and won, and the district court judge said, well, you guys are all public officials, you're public officers. Your emails are public, you got to give her everything. At the circuit court level, they stepped back from that and said, wait a second, no, you don't have to give her something if it's not in the transaction of public business, because the statute defines it that way. What we are going to make you do, though, is anything you're withholding, I want you to list it. And just, short description of, I have an email on this date from this person, it's about personal business. Something like that. So that was the last point where I saw, and I don't know if that's being appealed further, but we'll see. We'll see what happens. Judges, that ruling will only be controlling in Loudoun County since it's at the circuit court level, but if it gets appealed to the Supreme Court, they may come down with a ruling that affects everyone. So we'll have to wait and see what exactly happens with that. For now, though, if you get something from your significant other, your spouse, saying, hey, can you pick up some milk on the way home? That's not going to be public record. That's private business. Somebody invites you to go see a movie with them or go to a picnic or go bowling or whatever it might be. That stuff is personal business. It's not public. Okay. Once we have public record, are there any questions about what is not a public record?
Well, for us, student records, financial aid applications, those are
Public record on the level of, is it a public record, something that you have possessed, owned by, prepared by, in a transaction of public business? Sure. Is it exempt? Yes. That's going to be the next step. Because the first idea, once we've identified something as a public record, as Maria puts it, I don't want to mess up her analogy, but basically it's like a baseball game, and you're pulling them out of the bullpen and putting them up on deck. They're up to plate, and it's up to bat, and you're waiting to see that, are you going to hit it out of the park and send it over to the public who's requested it, or are you going to send it back to the bullpen? And if it's exempt, you can send it back to the bullpen. And most student records, scholastic records, back to the bullpen. Those ones are not ones that are going to be sent out, even though they are, under the basic definition, they're a public record. Now, one of the ideas here is all public records are presumed open. So when you're first looking at it, you're saying, yeah, I'm going to send it up on deck, and unless there's something out there that says send it back to that bullpen, I'm sending it out. I'm letting the public have it. So there's also a rule, and this is my Johnny Cochran moment, is when in doubt, give it out. Okay? If you're not sure about something, if you're looking at it, you're going, I think this exemption might apply, but well, I'm kind of stretching it. Don't stretch it. FOIA doesn't stretch. It says in the policy section that all exemptions are to be construed narrowly. So you're going to have to look at the exemptions really narrowly. On the converse, it says everything else about FOIA is to be construed liberally in favor of openness. It says policy section about all the affairs of government are not meant to be conducted in secret. They're meant to be done for the people, for the benefit of the people are to be made aware of them. So the basic idea is if you've got a public record, it's an open record unless there's a specific exemption. So when somebody requests a record, one of the questions is, who can request a record and how do they do it? that's the next step. Any ideas as far as who is allowed to request records under FOIA? Media? Anyone else? Is FOIA just for the benefit of the media?
General public.
Taxpayers?
General public.
Taxpayers, general public? I like these answers. Okay. Specifically, it says citizens of the Commonwealth and news media with circulation or broadcast in the Commonwealth has the right to make a records request under FOIA. My advice is to answer just about any request from anybody, regardless of whether they say they're media or just a citizen. There's a couple reasons for that. The basic and practical reason is if I'm Joe Schmo from Oregon. You don't know me at all. And I come to you and I say, hey, I really want to see the school statistics on blah, 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 whatever it is. Statistical records are almost always open. There's very rarely going to be any sort of exceptions that apply to them. So we'll assume it's an open record. But you say, wait a second, you're from Oregon? I don't have to give you that. Are you right?
Yes, he said
Yes.
citizens of Commonwealth.
Sure. I say, okay, well, I'll get my cousin. He lives in Fairfax. He'll make the same request. There, you just answered it twice when you only had to answer it once. You could have just said, here you go. That's the practical reason. Almost anybody who's going to request a record in Virginia, they've obviously got some sort of interest in Virginia. They've probably got a friend who works here, a business partner, somebody they know, a registered agent, if it's a business that does work in Virginia. Maybe their kid's a student here at the school. And maybe the kid's not actually a Virginia citizen either, but guess what? I bet they know one. I bet every kid here knows at least one Virginia citizen who will make that request for them. So, as a practical matter, it's just the easiest way to do it. Anybody want any further discussion of that on the legal side? I can. Question?
Those of public record, everyone sitting in this room does not have the authority to give out information.
Well,
So,
I mean, you do and you don't. As far as who is the custodian of public records, that becomes a question of getting that request to the right person. And if y'all have a designated, this is our FOIA officer, whenever you get a request, and this is a good idea to encourage everybody, get it to that FOIA officer. Just make sure you get it to them and get it to them quick, because they've only got those 5 working days to respond. So you want to do it as fast as possible. And it's easy. On the other hand, there are things that a lot of people probably, front office handle a FOIA request all the time without even thinking about it. If you have something like a statistical report on donations that's been given to the school, a fundraising effort, you want to promote your fundraising, so you write up a statistical report, and you've got 30 copies sitting at the front desk for anybody who wants it, and I walk in, hey, can I have a copy of that? Sure, here you go. That was a perfect FOIA transaction. Nobody said FOIA. No one put anything in writing, but it was FOIA, and it was done right, both sides. That's all you really got to do. So I hesitate to say you don't have authority. I mean, there may be some things that are, you definitely want to get them to that FOIA officer, so get them to him, and that's fine. That's all you have to do. With the same idea there, with how to make a request, was the next part of, besides who can make a request. I'll just tell you, as far as citizenship, there's a couple legal reasons. There was a case not in Virginia's jurisdiction, but it's a federal case from Delaware that went to the Third Circuit Court of Appeals, where a New York citizen made a request to Delaware. Delaware's FOIA was limited to Delaware citizens only, and so they said, no, we're not going to give it to you. He sued them in federal court and won on constitutional grounds. Under Privileges and Immunities Clause of the U.S. Constitution. They appealed it up to the Third Circuit, who affirmed he was right, the guy from New York. You cannot limit your FOIA to your own citizens only. So we haven't had that case here in Virginia yet. It's only persuasive authority, but we were told now it's about a year and a half ago that somebody's looking for a plaintiff. They're looking for a chance to sue. So if that's the case, you don't really want to be the federal court test case. So, that, just a practical matter, they're going to come back to somebody else making the same request. I wouldn't limit it to Virginia citizens. Same time, a common question I get, what if they're from China? Well, if they're from China, use your best judgment. A lot of the time you're going to say no. You're from China, I don't have to answer that, and that's going to be the end of it. And it's true. If they're not a citizen, under the current law, you do not have to answer it. If they're not a citizen of the news media. Then again, we've heard questions of, somebody from Hong Kong, they really did have a cousin here in Virginia who's going to do the same thing and make that request for them. So use your best judgment on that. One other just cautionary tale of what not to do. When responding to a request, if there's an exemption, you have discretion. keep in mind that this is discretion regarding whether you should release the record or not. It is not discretion regarding who the requester is or what they want. Supreme Court had a case, Virginia Supreme Court, about 20 years ago, where they said the purpose of a request doesn't matter. So it doesn't matter why a citizen wants the record. If they're a citizen, they have a right to get it unless it's exempt. And here's an example of what not to ever do. I don't ever want any of you to call me up like this woman did, who called me up and she said to me, well, I work for a county supervisor and we've got a records request for some of his records and I don't think we want to give it out. Well, are they exempt records? Is there something about the record? Well, no, they're open. We're not sure that the person requesting is a citizen. Really? Well, are they from Virginia? Under Virginia FOIA, you can ask for somebody's name and their legal address, and they have to give it to you. Did you do that? Well, yeah, they've got a Virginia address. I don't think they're a citizen. Well, what do you mean by that? Well, I don't think they're a citizen of the U.S. Okay, well, what's your basis for that? The last name is Torres. That's a quote. She told me his full name. I'm not going to go further, but that's exactly what someone told me. And I said, man, you do not want the editorial that's going to be written if you say no to this person because of their name. And your supervisor, you just told me a minute ago, they're up for re-election this year. Don't do it. Just don't do it. Don't go there. So that's something that some people, I'll tell you, some people use it as a policy of if there's an exemption, we always use it, just to avoid any questions of discrimination. That's improper. They say if there's an exemption, we're going to always choose to use the exemption and withhold the record. FOIA does favor openness, so you're always welcome to give stuff out. I don't recommend making a blanket policy to always say no whenever you can say no. I think there's times when you're just going to want to give something out. A common example of that, if you get a record and you're allowed to give it out, but you don't have to, but there's a lawsuit going on, and if you say no to the FOIA request, the next thing coming to your desk is going to be a subpoena from the court. Why say no? Just give it out, because you're going to give it out anyway, one way or the other. So, try to keep it on a practical perspective, what you got to do when you have this discretion. Just don't abuse your discretion. On that level, let's go to how to make a request, a responder request. How to make a request is really simple. I want that record. Can I have a copy, please? Thank you. That's all I really have to do. You can ask them for their name and legal address. Like I said, they're supposed to be a citizen or representative of the news media. We don't recommend limiting it that way. But all they have to do is say, I want the record, and identify what the record is with reasonable specificity. Practical question. Somebody comes in and says, I want to see every record you've got that uses the words, in quotes, staff recommends. If you got something that says staff recommends, I want a copy of it. Is that a reasonably specific request? See head shaking. Anybody want to nod? Yeah. Why is it reasonable? Why is that a reasonably specific request? Staff recommends? Yeah. The idea is, I want everything that says those two words, staff recommends, and that's all I want. It's a very specific request. You know exactly what they want. But it's huge. It's reasonably specific. Is it reasonable as to volume? Well, it's going to be gigantic. Yeah, how long is it going to take to find all those records, search all the databases, go through every filing cabinet? Huge request. I think anybody in government would agree that's just a massive request. Is that a reason to say no? No, that's not. You can get more time, and you're allowed to charge for your time. And once people see the estimate you're going to give them, they're probably going to say, well, hold up, let me rephrase my request. And that's part of the process of doing a FOIA. They make the request, and if necessary, you talk to them, get it to narrow down to what they really want. But if they say, oh, you think it's going to be $50,000 and you say 6 months? All right, here's a check, and I'll wait. Take your time, but I do want it. What do you do then? Get to it. There you go. There you go. I think the highest estimate I've heard lately is $12,000 for vehicle fleet records for Department of General Services, which you can imagine they're the State Department of General Services. They have a few vehicles, and somebody wanted all the records from every vehicle for 3 years. And they said, initial estimate was about $12,000, and they said, we're happy to work with you to cut it down. Last I heard, they cut it down to about $6,000 estimate. I've heard of people paying $3,000 estimates, and just, fine, I'll cut you a check. I do want the records. and then suing later over the costs and winning. But that's another story. Basic idea though, somebody comes in and asks for records, that's all they have to do. Some people like to use a form, and that's fine. If you want to use a form and say, could you please fill this out, that's okay. If you say fill this out, or else I won't give you the records, that's not okay. They don't have to fill out your form. If you want to, you're welcome to fill out the form if they say, I won't do it. If you got somebody who's stubborn, I'm not going to fill out your form. You fill out your form, Okay. You can go ahead and do it yourself. I would recommend, in fact, it's always a good idea to have it written down. That way you know what they asked for and when they asked for it. And I tell the same thing to requesters. When you make a request, write it down so you know what you asked for and when you asked for it. That way, if there's ever a question, if it ever goes to court, it's recourse for both parties. It protects you. So it's a good idea to write it down, but you can't make them do it. Do it yourself if they won't.
How about
Yes.
police records? How about police records?
Police records?
If there's any
Police have a
records?
lot of exemptions. Probably the two biggest ones are for criminal records that are used as evidence in a prosecution or investigation. I'd have to read out the whole thing, but it's complaints, memoranda, evidence, almost anything in a criminal case they can withhold. The exception to that in felony cases, they have to give out criminal incident information, which is your basic police beat kind of stuff, general location, general description of the crime, officer who's investigating, the very general information. They don't have to give that out in the case of misdemeanors. And also in the case of non-criminal records, various incident reports,
You said except for misdemeanor?
misdemeanors. They do not have to give out criminal incident information for misdemeanor
Little
cases,
crimes.
only felonies.
Only what?
Felonies. Felony
What's
cases.
the difference?
More than a year in prison punishment for a felony. Murder, rape, armed robberies, burglaries, most of that stuff's going to be your felony category, whereas a lot of misdemeanor, students in a drunken fight at the Commons kind of thing, on a Friday night, a lot of times misdemeanor, they pull a knife or a gun, a lot of times that's going to be a felony. But it's a lot of it's up to the prosecutor, because sometimes the same thing could be either, depending on the severity. But usually the felony is the more serious crime, and that's the one they have to release at least basic information. For felonies, yes. For non-criminal incidents, they can redact out personal, medical, or financial information to protect someone's safety or privacy from the non-criminal incident report, but otherwise they would give it out. Also, arrest information. If somebody is arrested and charged, the status of the charge and the arrest, the identification of the person is open. That changes once it's become criminal history and the person is out of the criminal justice system. Criminal history in Virginia is prohibited from release except to certain parties. So only, background checks and stuff for employment, they can usually get a criminal history. The person can get their own criminal history usually. If you go to work for a daycare, I think a lot of schools can do background checks. You have the right to do it, but a lot of other places do not. I can't go get your criminal history, for example, but you can get your own.
What happens if there's criminal action and no charge?
As far as what records exist, I don't know what they're going to keep. Because I would think if they're not charged, they're probably not going to get into the criminal justice system as far as the criminal history check. But they might. If somebody's charged and charged dismissed, that could be in the record. That's an individual records keeping question. Next part is responding to a request. This is kind of the meat and potatoes stuff of the FOIA procedure. FOIA is mostly a procedural law. I need everybody to do me a favor and do this with me. Okay. How many responses are there that you're allowed to make to a FOIA request?
5.
How many days do you have to respond?
5.
Excellent. Thank you. You're all great students. Thank you. Basic idea, we already discussed there's 5 working days to respond to a request. You do not count weekends or legal holidays. Does anybody have questions about that one? That's pretty simple. Next part is there's 5 responses. I'm going to run through them real quick, and then we can talk about each of them in a little more detail. Number 1, here, have the records. That's your first easiest response. 2, 3, 4, and 5 all require you to make your response in writing. Number 2 is no. I'm not going to give you those records. Number 3 is, well, I'll give you some of them, but I'm not going to give you all of them. Number 4, we don't have them. Number 5, I need more time. Those are your basic responses. They pretty much follow common sense. When you're saying no, You're required to identify the subject matter, the volume of the records, and whatever cite to the law allows you to withhold the records. So, for example, with scholastic records, you're going to say, I have 30 pages of scholastic records reports that identify individual students, and we're not giving them to you pursuant to 2.2-3704.1, or 3705.4, another one, excuse me. Sorry about that, but that's your scholastic records exemption. You also might say, this is directory information under the Family Educational Rights Privacy Act, so I am going to give it to you. But the other part of it is withheld because it's not directory information, it's a scholastic record, and so I'm giving you part of this report, and I'm not going to give you all of it. And in that situation, again, you have to give it to them in writing. You don't have to identify the volume anymore because they'll see what's been blacked out and withheld. You do still have to say the subject matter of whatever you're withholding, and you have to give them the site again. So that's saying no, and saying no in part, yes in part. Next one is really pretty obvious. We don't have it. They do. Or we just don't have it. We never did. We don't have it. We destroyed it. Is everyone familiar with the Public Records Act and all? It's kind of in parallel to FOIA. It's the act that talks about record retention. It has the schedules for destroying records once they're after a certain age. Usually it's about 3 years, sometimes 5, sometimes more or less. That act is administered by the Library of Virginia, and if anybody needs questions about that one, you would contact them. With the FOIA and that act do interact a little bit, but the basic idea there, if something is the subject of a FOIA request and it comes up for destruction, don't destroy it until after you answer the FOIA request. Other than that, though, if you've already destroyed a record, you don't have it anymore, someone asks for it, I'm sorry, we destroyed it, according to the Public Records Act and the retention schedule. We just don't have it anymore, so sorry. And that's a perfectly valid FOIA response. Again, put it in writing and just explain what happened. FOIA does not require you to create a new record or recreate a record in that sense. So if it's gone, it's gone. Similarly, one we get a lot, people come to us and I want to get my own criminal history check background, or I want to get my college records, I want to get my Medicare records, Medicaid records. We get questions like that all the time because we're the Freedom of Information Advisory Council. People say, oh, you have all the records. Well, we don't. We only have our own. So I regularly tell people, we're the FOIA Council. We do this. We educate about FOIA. We discuss FOIA. If you have a FOIA question, I'm happy to help you, but I don't have those records. Instead, you need to contact whatever agency it is that'll have it. We try our best to figure out who that is and give them the contact information. That's what, if you don't have it, somebody else does, you're required to do that. Anybody want to hear a story? Okay. That didn't used to be in the law. It got put in last year. And we kind of hoped it wouldn't need to be put in the law, but we had a number of situations where people weren't saying, I don't have it. Sometimes people weren't responding. I asked for a record, we'd get a call up, yeah, I asked for this record from the Department of whatever 3 weeks ago, and I haven't heard back. Well, I'd go through that 5 days timing. When did you make that request? When did they get it? Do you think it could be in the mail? Well, it could be, but I made the same request 6 months ago, and they didn't respond then either. You go, wait, so they just didn't respond at all? Well, would you like me to make a courtesy call and, talk to them? Like I said, our office is happy to make courtesy calls and discuss things with people, try to work it out. So I placed a call. Oh, we don't have records like that. I don't know why that guy even asked us. But no, we just don't have anything like that. Well, it didn't used to be a response in FOIA because people just said, common courtesy. If you don't have it, just say, I don't have it. But people weren't doing it. So it's now in the law. Another example, this is one of our published advisory opinions. Somebody made 70 written requests numbered out in a letter to a State Department. And among other responses, they said that record is not available. Anybody know what that means? What does that mean? They don't have it?
Which ones you make 70 before?
Well, it's to a whole bunch of different ones for different records. They said that record is not available. Yeah, it might be tied up somewhere. It might be, hey, I don't have it, I'm just not going to give it to you. It's not available to you. I don't like you. Is that acceptable under FOIA? No, that's not good. Could be, we don't have it, we never did. We never will. It's just not something we do. If somebody wants a Medicare record from my office, I don't do Medicare. I don't have any Medicare records, so I just can't answer, that. But I tell them, I don't have it, go to DMAX, So we saw a few different situations like that, And so we had to say, we need to get a change put in the law, require it now. So if you don't have a record, tell them you don't have the record. Yeah. Next part on timing, we discussed the 5 working days. What if that's not enough?
Did ask for an extension.
Yep, you can automatically pretty much invoke a 7-day extension if you don't have enough time in that first 5 working days. You get an additional 7 working days. Again, you have to respond in writing, tell them why it is practically impossible or impracticable to produce the records in the allotted time. So if you just can't do it, you can always get 7 more days. Remember I talked about $50,000 and 6 months and all that? We actually discussed something with somebody who got a request from a lawyer that read like a discovery request in court. And if anybody's seen one of those, they write it as broadly as possible to make sure they cover everything so you can't slip out of it. That's what we lawyers do. But when you do that in a FOIA request, and it's public records, you're going to get it. And a lot of times, it's going to be big. We had one where, I believe we were talking to the Port Authority, and someone wanted, among other things, all of their inspection reports. Well, when we talked to a member of the Port Authority, they run all the ports in Richmond. A lot of their major equipment is inspected daily, sometimes multiple times a day. They have multiple safety inspections of all their facilities, all their equipment, incoming cargo haulers, all this different stuff. He was saying that each facility generates hundreds to thousands of inspection reports of different kinds every day. They wanted this for, I forget, a 5-year period or something. He said just that aspect, and the whole request was much broader, but just that aspect, he was probably running $100,000 right there just to make the copies, never mind search time. So, I think he worked that out with the requester and explained the situation and got it handled. But if I remember right, I think he said his initial estimate that he asked for was about a $20,000 estimate. And how much time is that going to take to get hundreds of thousands of copies of paper made? Clearly 5 plus 7 working days just wasn't enough. When that happens, try to work out an agreement with the requester. The law says you can petition a court for more time, but only after you've made reasonable efforts to reach an agreement with the requester on the production of records. So, last resort, if the person's obstinate, I want it in 5 days. I want it in 5 days, and I will not give you more. Well, then you can petition a court, but only after you say, well, sir, we can do it within 12 days, I think, and we'll even give you a discount on the charges. We'll lower the price. That's a lot of time you got to make a trade-off, and that's the typical one, is you lower your costs in exchange for getting more time to answer the request. Most of the time, that's going to work. I've honestly never heard of someone actually having to petition a court. I talked to a couple of cops up in Northern Virginia who said every single time they've asked for more time for a requester, they've gotten it. Every requester has been agreeable. They've managed to reach that, and I'll tell you, people interacting with the police is usually the most obstinate, hard-headed, I want it now, we're not going to give it to you kind of situation, but they said every single time they've managed to work it out. So you should never have to petition the court, but that option is still on the table if it ever gets to that point. Are there questions about those 5 responses? Okay, we'll move on. And so we already talked a little bit about creation of records is not required. Something to keep in mind, if you've got an electronic database, you've got a number of fields in it, and let's say one is statistical information about people's SOL scores, and the other identifies student names. Well, obviously you're not giving out student names as collective record, especially if it's attached to their SOL score. But just the statistical information, that stuff's open. So when you respond to a request for that database, you're going to pull one field and you're going to leave the rest in. That is not considered creating a new record. That is just excising and redacting from an existing record. So, and that's specifically set out in the law, because there used to be some questions about that. There are times when creating a new record means, juggling databases and stuff where you have to, for example, create a new program. We've heard people doing this where they had to get IT people in to combine records from multiple databases that were not compatible, and they had to write an entirely new program to do it and then make it into some different readable format, and a whole bunch of work involved. That's a separate situation. Usually creating a record means something where you abstract or summarize from existing records. The law specifically provides that you can do that by agreement with the requester. So, for example, they want your SOL test scores for all the female students over the last 4 years by semester. Do you have that already made? Do you have it in an existing database where you're just pulling out fields? Or would you actually be creating something new? Probably creating something new. Do you have to do it?
No.
No. You can tell them, well, here's all the information I've got that we have on our SOL statistics. It's all open. You can do the math and figure it out yourself. Or you can say, I'm willing to do it. Sure, it's not hard for me to run that and pull it up, but these are my terms. And if you're going to create something new, get those terms set forward in advance and make sure they agree with you. Otherwise, you just did a lot of work for free. We have had a couple situations. I'll give you one example. It's in our formal opinions. Where a man asked for everybody's salary information and wanted names, positions, job titles for people in a public department. That's all public information. Congratulations, everybody knows what you make if they want to. Me too. It's the way it is. Consequence of working for the government, working for the public sector. But he asked for that information. He asked to inspect it. And they sent him a response that said, okay, we've compiled a spreadsheet with all the information you want. That'll be $207.50, please. Okay, there's some problems there with the whole charges idea. We're going to go to that next. But part of the whole thing, one, he has to inspect, and it's the citizen or requester's right to get copies of the record or to inspect record. It's their choice. So if they want one and not the other, give them the one they want. Don't do the other. In this case, he wanted to inspect records, and they didn't give them the option of inspection. They said, we compiled this, made copies for you. Here you go. Pay us this money. And he said, no. I just wanted to look at them because I didn't want to run up a big charge. I'm not going to pay for this stuff if you did it without my permission. The other part was they went ahead and created something that did not exist. They had created this new spreadsheet with everybody's title, name, position, and salary that did not exist before. And he said, I didn't actually create anything. And they said, well, there was an old Attorney General's opinion that said one of the few exceptions to the do not have to create rule is if it's for job position and salary information. You do have to create that if you don't already have it. As a practical matter, do you believe the government does not have a record of what they're paying people? We have records of what we pay people. They're out there. So, it didn't really seem necessary. It might have been easier to go ahead and compile the spreadsheet, but it wasn't really necessary. And the big thing was he never agreed to it. They ended up having to give it to him for free. I think he did sue him over that one. That case, I'll just tell you, it involved gaming in the fisheries department. Has anyone been reading the paper on that lately? Where I heard that the first person who just went to trial, they dropped the charges, actually. But there was a whole internal auditor's report, about 50 pages, that went through a whole lot of things. The big one that hit the news was there was a safari to Africa where they paid for a lot of equipment with a state credit card, and it involved, I believe, the then director and chairman and two of the highest level officers. They got in a lot of trouble. Well, they didn't. It's been 2 years that the state police were investigating. They finally brought charges against, I think, 3 of them. One of them actually paid back all the funds already for that. The charges have been brought, from what I heard, the first trial that dismissed the charges. So, no penalty yet on that as far as that goes. But none of them work there anymore. They've restructured the department. Major changes have been done. And a lot of it was a result of FOIA requests from one gentleman who actually, I believe he did sue the Department of FOIA 3 times. He got opinions from us twice and sued 3 times. So,
What about
if you had something like a job description that says this position is in charge of this and the goals of this position are blah, 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 that would be open as far as it's discussing just the position. But if it's talking about, my hope is that Alan will do 15 different FOIA trainings next year instead of the 10 he did last year. Something like that, that's an individual performance goal tied to me as an individual, my identity. That's a personnel record you can withhold. Something about how much did Alan make last year, that's open. It's taxpayer dollars. I work for the public, the people of the Commonwealth, they pay me, they get to know who works for them, how much they pay them, and what job I'm in.
So essentially very specific to an employee or employee
Yeah, generally.
job title, et cetera, is private and personal.
It really works kind of on a 3-stage process with personnel records. Because the first idea, as we said at the beginning, public records in general are open, they get up on deck. So if you've got something that is a public record about public employees, it's up on deck. You go, wait, this is specifically something about this identifiable employee. There's an exemption for personnel records. You can pull it back. You don't have to give it out. But if it's salary, if it's reimbursements for expenses, that kind of thing, if it's an employment contract, those go back out and they're out in the park, give them to people. there's a specific exception to the personnel exemption, which is kind of complicated, but the basic idea is, remember, if it's taxpayer money, it almost always comes out, if that's what it boils down to. If it's who you work for, directory information, if you want my email at work, you can get it. You want my email at home? No, I'm not going to give it to you. That
So
kind
the
of thing.
criteria basically for the performance evaluation, for instance, for me, okay, you
Mhm.
say the criteria for your evaluation is developing relationships with your colleagues, producing this so many times. That's not public record. So it's
The record, well, this is, it's actually a good time
the
to.
criteria that you are evaluated on.
Yeah, as far as if there's a blank criteria, that actually, you might be able to withhold because there is an exemption for tests and evaluations given, both to students and employees. So with that exemption, you could probably withhold even a blank one of those. But let's say there was just a, I'm trying to think of my job position as staff attorney for the council. You will.
PSAs are this.
Yeah, I think
you're not
it's
gonna
stuff.
use this. It's
Yeah,
fine,
you will
right?
do this, blah, 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 blah. That stuff is open. If there's a specific aptitude test that you have to take to get the position, they can withhold the test itself, but they would give you your score on it to you. But to anybody else, they're going to say, no, I don't have to tell you how she scored. But again, if I want to know, once, let's say, did you say you're a dean? Do you have an employment contract with the school?
Yes, it's,
Okay. If somebody wants to request your employment contract, that's open. That's an open record. If somebody wants to request your interview notes when you got that signed and everything, that's closed.
Pardon me.
The only person who can get that guaranteed is you, because they're your interview notes. Same idea, but back again, is if there's an employment grievance and that's settled by a contract, that contract can be withheld. So a settlement contract, you can say, no, we're not going to give that out. But a standard employment contract, you would give out. And again, all these get a little bit complicated, so feel free to call me if you got a specific question. But let's see. We want to talk about charges. How much time do we have? Oh, good. We have some time. Charges is always a good thing. You are allowed to charge up to your actual cost for searching for the records, accessing the records, duplicating the records, and supplying the records. Specifically, it says your public body is allowed to make reasonable charges up to the actual cost for those 4 items. Anybody know what a reasonable charge is? All right, me either.
Isn't it subjective?
Well, it's not really subjective. What it is, it's a question of fact, and it depends on the fact of every case. So the only way you ever find out what a reasonable charge is for certain is if somebody sues you and takes it to court. Then the judge or the jury will tell you that was reasonable or that was not reasonable. You did it right or you did it wrong. That's your 100% certain way. Other than that, use your common sense. And if it makes you go,
Hours, number of copies, et cetera.
yeah, most of the time it's pretty easy to compute this stuff out by your actual costs, and that's what we'll tell people is I can't tell you what's reasonable, what's not, but I can tell you what's actual cost and not. So if you're within actual, you're at least a good ballpark, probably going to be reasonable. Let me tell you a story. I love stories. Again, this is a real story. Someone called me up and said, well, we have this woman who keeps making requests, and it's getting, it was getting kind of annoying. She was making a lot of requests, and we used to do them all for free. Just because we're nice, and most people don't request more than a page or two at a time, so it's more of a pain to actually charge them than it is to just give it to them. So we gave her all this stuff for free, but it started adding up. It's a lot of paper. We actually went through a toner cartridge, which it's a small town. We usually go through a toner cartridge every 2 years. And all of a sudden we were going through one every 2 months, and so we started charging her a nickel a page. I said, okay, what do y'all think? Is that reasonable? Yeah. I think we're probably well within our actual cost at that point. She said, well, she kept making requests and we raised it to 10 cents a page. Are you still reasonable? I'm 50-50 on it because it might still be within actual cost, and it is costing them that money. It's reasonable. They want to recoup the cost. That's what FOIA allows. So as long as they're still within actual, I think that could still be reasonable. What do you think she said to me next?
25 cents.
25 cents. Good guess. And you know what her question was? Now they want to raise it to 50 because she's still making requests, and I still think that's right. Can they do that? I said, no, I think you would pass when you hit 25, most likely. And it's one of those, it's 25 cents even then.
fee.
Yeah, exactly. That's exactly what it is. And is that right?
No.
No. You can't use FOIA to deter a request. You're not supposed to use charges for that. Because, again, the whole idea, it's the people's government and the people's papers. I forget who said it, it's Maria, but Maria said it to me. They've already paid for it once. How many times are you going to charge them? So that's the idea. With charges, I want to go ahead and I don't know what's going to happen if I write on this thing. So, well, yeah, I'm going to avoid writing on this stuff because I don't know what's what on these different things. Yeah. I guess we'll just go through it kind of one at a time with each of the items. Accessing. Your basic idea is you walk up to the front desk and say, hey, I want a copy of report X. And I'm behind the desk and I go, I know where that is. I walk over to the file cabinet. Here it is. I just accessed the report. If necessary, I flip through. I searched for the report as well. Okay, duplicating is pretty obvious. I put it on the copier, run it off. Here you go. Supplying. That's the here you go part. Questions on that? Okay. It gets a little more complicated. You get an email or a fax comes in or somebody verbally calls you up on the phone, hey, I need a copy of this report, let me give you my information. You're taking down stuff. Anybody here have off-site storage or is everything here on campus? Pretty much on campus? That's good. I'll tell you something, because you never know, you guys might be on the other side of the fence someday making requests too. It does happen. One thing that we've heard is when they use off-site storage, some places actually charge you every time you go in and out of the gate. And if that's the case, can you pass that on to a requester? Anybody want to say yes, absolutely? Well, I'm going to say yes, but. Because if the only reason you're going to that site is to get records for that requester, yes, you can pass that access fee back to the requester. If you're going out there anyway, and you also happen to be getting records for them, no, don't do it. Because FOIA specifically says you're not to charge general maintenance overhead, the cost of general doing business, any of that stuff, cost for the lights, cost for renting the storage facility, any of that stuff, no, you do not charge for that. With copy costs, I did not bring them, and I'm sorry, I forgot at the last minute, but we have a booklet on charges, and it is available on our website if you look under the reference materials guide. And in that booklet, there's a specific formula to compute out the cost of reproducing one page on your copier. So you can actually figure out what the cost of one page actually is, just to make sure you don't go over. It's a good idea to have somebody, whoever actually does, the purchase contracts and knows what all the pricing is, have them compute that out, every year or so or whatever, if they get a new contract, new supplier, prices change, it's time to recompute. But it's a good idea to do that just to make sure you're not going over, because if you're going over, you can get sued. And you don't want to get sued over something because you charge a penny too high or something. That's just pointless. Let's see, the charges now, you got accessing, supplying, that's pretty easy most of the time. It's either handing them the records, it's mailing them, you can charge them for postage in the box to put it in or the envelope. Duplicating, again, copy costs right there. And searching. Searching would get into time. What can you charge for your time?
Per hour.
Per hour. Your hourly rate. You can charge that. Anybody here salaried? What's your hourly rate? Do you know? I don't know why either. If you know it, you can charge it generally, but
Divided by whatever.
Yeah,
2,080.
2,080. Thank you.
2,080.
Divide so you
What's
can
2,080?
You multiply your salary. I mean,
40
24
hours.
times, what
Yeah.
you make, okay, and then you divide it by 2,080. That's what you make
Figure
an
out
hour.
your hourly. Do you include your benefits?
No.
Correct. You do not include benefits. We've seen people try to do it, but benefits are part of the cost of doing business generally. They're not part of responding to a FOIA request, so you don't add in your benefits. The big questions with that, I had this the other day, can I set a flat rate and just charge $35 an hour for all responses to FOIA requests? Anybody think that's reasonable? Okay, no. Anybody think that's actual cost? Probably not, because, and what I said was, do you have anybody in your office who answers FOIA requests, does some of the work, who charges less than $35 an hour? Well, yeah. Well, then if you're charging $35 an hour, you're charging too much. You can charge whatever the minimum rate is for whoever the absolute minimum person's doing that FOIA request. That's allowed because anybody else is over it, so you're at least within your actual cost if you do that. And I'll tell you, I think it was DMV did this. You have multiple campuses. Do people in the same job position get paid different rates depending on where they are? I'm just curious.
No.
Okay. Well, I'll tell you, with DMV, since they're statewide, they're talking about they have 9 regions and pay is by region. So, a DMV teller in the office down in Southwest Virginia is not paid the same as one in Arlington. Very different rate. So they said what they did is they looked for the lowest common denominator, that lowest rate of pay for anybody who'd answer a FOIA request per region, and then set that at the flat rate. Now, can you charge more than that lowest rate? Sure, if it's the person who's actually doing it is paid more, yeah, you're within actual cost. Is it reasonable? That depends. I'll give you an example that I like to use just for people to think about. Let's say police are building a new jail, and so the police chief has been talking to contractors about different issues, and it's on his email on his computer. And you say, I want every email back and forth between the police chief and these contractors. Let's assume this stuff's all open. Who's going to answer your request? Secretary or Administrative Assistant?
Or maybe the police chief himself.
Or maybe the police chief himself, yeah, because a lot of time, if that requires full access to his email to search all that stuff, a lot of time he's the one who's going to do that. He's not going to give his password to anybody else in the department. And again, we have a dean. Are you going to? We have a police chief. Excellent, good. So would you all let somebody into your own? No, you're going to do it yourself. Are you going to charge your full rate? And that's, well, depends on what you're doing, I think. Because honestly, I'll tell you, we got a FOIA request and we don't charge because we're the FOIA. We just don't charge people. But we had a request because we keep call records of all our calls that come in. And the guy said, I talked to Maria back, I think it was 2003 or something, about 3 or 4 times. I know you guys keep records and I need them because I'm suing them now over FOIA or whatever it was. So Maria said to me, hey, can you look for all our call records with this guy's name on them? I said, sure. So I went over to the file cabinet and I flipped through, searching. I pulled them, accessing. I went and made copies. That's duplicating. I handed them to a secretary to mail to him. That's supplying. All that, we could charge for it? Sure. Let's assume we did. We didn't, but let's assume we did. I'm an attorney, and I'm licensed by the state bar. Do I charge an attorney rate for that work that I just did? Let them through the file. I like it. Say it loud. What are we talking about? No, of course not. Was I acting as an attorney? Did I provide legal advice? No. It would just be wrong for me to charge an attorney's rate on that. At the same time, if somebody came to me and we've got a FOIA request, I work for the police. We've got old records that are, these are about 9 years old. And when this guy was arrested for robbery at the time, we're not sure of the disposition. We're not sure that this guy went to jail or not. I think he did, but I don't know. I don't know if he's still in jail. I don't know if he's out of jail. What I do know is there's a prohibition on release of criminal records, criminal history records in Virginia. And if I do it wrong, I get charged with a criminal misdemeanor. We have criminal history records improperly. I'm taking it to my lawyer. Well, what do we do with this? Well, now that's involving legal advice. I think you have a little more justification. At the same time, I'll tell you, we've issued an opinion. Getting a second opinion from your lawyer, getting a legal review of a matter, is not really responding to the FOIA request. That's the general business, because that's what your lawyer does for you. So we don't usually say you would charge a legal fee in that instance. I'm going to step back a little and talk about reasonable and about charges for hours. You tell me if you think it's reasonable when, and this really happened, I think it was a county administrator, again, sick of this woman's FOIA request, sent her off an email, and she forwarded the email to me. I'll talk about email in a minute. And she forwarded this email to me with the county administrator saying, from now on, whenever you make a FOIA request, I'm going to respond personally, and you have to pay my rate of $50 whatever an hour. And if I'm not here, the director of finance second highest paid person in the county at 48 an hour will respond to your FOIA requests. Reasonable?
No.
Good.
None are annoying.
Good. Quick learners. Good. That's no, you can't do that. So again, and that was an example. They were charging that high rate because their position, that's their hourly, and saying I'm the actual, so I can do it. Well, were they within actual cost if they actually did that? Yeah, but is it reasonable? Again, common sense says no. Again, it comes down to that situation, as police chief and as dean, are you going to charge your full rate? Maybe. If what you're doing and responding to requires you to be that person in that position, and it requires your expertise as chief or dean to respond properly, yeah, I think you've at least got a justification. At the same time, as a public policy matter and a matter of public relations, you're probably better off charging a lower rate. Just people get along better. They don't like paying money. It's just the way it is. Let's see, with charges.
What about congressional requests? They can take a lot of time.
Congressional requests?
Like
Example.
charge for those, like when I used to work at NASA, there were all kinds of requests from Congress and Congressmen for all kinds of data.
Did you say when you used to work at NASA? Okay.
Yeah, that's a contract.
Okay. Well, I'm not going to give you a good answer to that, unfortunately, because the answer is it doesn't fall under Virginia FOIA. Because when you're working at NASA, number one, it's federal FOIA. They have their own unique charging rules. The other thing is when it's a request from a congressman, even under Virginia FOIA, like if the congressman made a request to you now, let's say a Virginia congressman did, so we know they're a Virginia citizen, they certainly have every right to make a FOIA request as a Virginia citizen, just as anyone here who is a Virginia citizen and works for the government. You're still a citizen, you can make a FOIA request just like anybody else. But if you ask me for something in your official position as an employee of a state agency, and I respond to you in my official position as an employee of a state agency, I think common courtesy controls. And technically, under FOIA, it says the rights are given to the citizens and representatives of the news media. So it's not really about government-to-government requests. And again, getting back to the real basics, it's government for the people, by the people, of the people. FOIA is the opportunity of the people to find out what government is doing. It's not really about government-to-government. It's different. That actually brings up an interesting point. Has anybody ever gotten a FOIA request or something, requesting records that cites 5 U.S.C. 552, and pursuant to this, I request a waiver of all charges because I am indigent person, because I'm news media, because it's for the public good, something along those lines? No? You will at some point, most likely. When you do, you might choose to educate the person and tell them that's federal FOIA. Federal FOIA has waiver provisions in there for certain purposes where if it is one of these things, you're supposed to waive your charges. Does Virginia FOIA have a waiver provision?
Have a
No?
what?
Waiver. Requiring you to waive charges for certain people? No. There is no such thing in Virginia FOIA. May you waive all charges and do something for free? Sure. Welcome to. Usually a lot of state bodies, especially in some localities, have a policy in place that says, if it's under $5, we don't care. Just give it to them. It's under 20, 50, 200. We hear 200 sometimes. Anybody know why it would be $200? What that's about? I'll tell you, the hint's in the statute. It says that if you estimate that a cost is going to be more than $200, you can tell the requester it's going to be more than $200, and I want you to pay an advance deposit of however much your estimate is. And at that point, you can stop working. You don't have to do anything more than that request until they tell you, okay, you said it's going to be $600, here's my check for $600, thank you. Then you would have to immediately start back up. We recommend in that situation, if you ever get one of those that's big and you're going to do the estimate, ask for the full estimate. Be prepared for them to negotiate back and forth, because this is a chance for them to narrow the request, lower their costs, which also saves you time and money because they're asking for less stuff. Always work with the requester on these, but don't go ahead and do the work without their agreement. We've seen, actually recently, we've seen a couple cases where people have gone ahead and said, it's going to be $300, and then they went ahead and did the work without hearing back from the requester, and they've now sent them a bill for $500. Requesters are not happy about that. They haven't sued them yet. We don't know if they will or not, and they also haven't paid the bills on some of them. So, and I don't know if they will do that or not. So it's, it's just, the general idea is, if you've got something over 200, tell the requester it's over 200, and if you want that advance deposit, get the deposit, tell them we're gonna demand it, and stop working. Don't do any further work. Along with that, anything that's over $200 is probably big. It's probably gonna be a lot of work. So give them that 7-day extension letter that you're not, at the same time. Tell them, we estimate it's gonna be, $500, $1,000, whatever it is, please send the advance deposit, and we estimate it's gonna take an additional, X days, so we're invoking the 7-day extension. Just to get all that out of the way. That way, when it gets back, if your response was sent on day 5, then technically, when that comes back in, you're supposed to give it to them immediately. But if you happen to work it, you can't do that. So make sure you get the 7-day extension in there.
Question, it's probably totally out of releasing information for juvenile.
Don't do it, generally. Depends on what it is. A lot of juvenile records are protected.
Okay.
So,
Can you say that a little louder in big, bold letters, please?
a lot of juvenile records are protected. Yeah. I mean, example I gave you earlier about arrest information coming out, it says except for juveniles. Yes?
Various states have ages for juveniles. Is Virginia under 18 or under 17?
I believe Virginia is 18 and under for most purposes. You'd have to, a lot of these laws about juveniles are outside of FOIA, so, you might have to look to other law to answer that question, depending on what it is. But I think generally 18 and under, or under 18.
Okay, because the media keep calling us, let's say there's a juvenile involved in a case, and keep asking us what's the status of that case. And, Chief has been always saying that's exempt, so.
Yeah. We addressed this in a formal advisory opinion and realized there's a lot of rules in Title 16.1 concerning the general district courts and the juvenile and domestic relation courts, where they talk about their court records, juvenile records. They also talk about law enforcement juvenile records there. There's also rules in FOIA in 2.2-3706. The very last provision of 3706 says that it's a trump provision, conflicts resolution provision. It says, in the event of a conflict between this section and another, this section wins. So for a lot of things under FOIA, you will have discretion, but then when you look at 16.1, they say don't give it out. So my advice, if you get that situation, is don't give it out, because you have the discretion to withhold it, and they're telling you not to. Don't. I think that's simple. If there are some situations where you might want to give out juvenile information for one reason or another, and if you have that discretion, you can. But if there's another law that says don't, I would generally, I would exercise discretion to say
the
no.
case and everything, so.
Well, it says for juvenile arrestees, if we're talking criminal context, it accepts them for the rule that you have to release information on the status of the arrestee and the charge. So that's exempt. You can also tell them go to the court. See what the court will give them, which is usually not much. Let's see.
Can I ask a clarifying question?
Sure.
Do you all have it now? You still don't. You still don't understand.
Oh, no, I understand. I'm just saying this for everybody because it's
Campus-wide.
campus-wide, that's what I'm
Hopefully
saying.
everyone
Yeah,
has it.
that's
Right.
one of the things to keep in mind.
people in here though.
But in the lunchroom, as soon as we walk out of the door.
Yes.
Yeah,
That's why I'm raising that question. It's
And I
just not,
appreciate
yeah.
I would refer you to the opinion, which, if I remember right, it's on our website. You would go to the searchable advisory opinions link. I believe it's number 7 from 2005,
Okay.
probably June or July. I may not be right. I know we had issued a prior opinion that was, I think, the second or third, it was an earlier opinion that same year, and we rescinded it because that conflict provision, we hadn't taken that into consideration at first, but with the conflict provision, technically, the FOIA section says it controls. So legally, where that FOIA section says don't give it out, don't give it out, where it says you have discretion, you would have discretion. Okay. With charges, there was another aspect. Kind of the flip side of this idea of getting the advance deposit, if you estimate it's going to be over 200, is if the person wants an estimate, give them an estimate. Example, remember I talked about gaming in the fisheries a little bit earlier? Okay, one of the lawsuits. Mr. Lee Albright is the citizen. He and his wife, Paulette, are the ones who were involved in making the FOIA request and suing the department several times. Basically, they're a retired couple. They live in Montebello, and they can see the Montebello fish hatchery by looking out their back porch. The fish hatchery was closing because they supposedly didn't have enough money to staff it. Meanwhile, they said they had been reading in the paper about bonuses given to the highest level officers and this safari trip to Africa and all this other stuff. And they said, wait, you can't afford to have a part-time person at the hatchery so that kids can come and look at this stuff, but you can afford to give all these bonuses. This doesn't make any sense. And he has subsequently publicly admitted he also had some insider information from friends who worked in the department as wardens and such. So he knew what to ask for, as well as he knew ahead of time a little bit about what was actually going on, so he knew what should have been coming back when he made his request. In this instance, he said he made, I believe, 3 requests on the same day, and he asked for estimates with each of those requests. The response he got had a blanket estimate for everything, and he said, you know, I really want separate estimates because I want to be able to tailor each individual request narrowly to get just the aspects of, you know, what I want to save money. I said, I already gave you an estimate. He said, I want 3 estimates. We already gave you an estimate. I want 3 estimates. We already gave you an estimate. Literally, they corresponded back and forth for 2 or 3 months, and then he filed suit. I believe, if I remember correctly, that was the case. The day before the hearing was to be held, they said, fine, here, have 3 estimates. Now drop the case. He said, what about my attorney's fees? They said, we're not going to pay your attorney's fees. He said, I'll see you in court tomorrow. He saw him in court, and they were wrong, have to pay the attorney's fees and the court costs. I think that was $750 I charged them. So the basic idea, if somebody wants an estimate, give them an estimate. The other thing about that, give them a detailed estimate. And the more detail you can put into it and say, we're going to have this person working at this much, and we estimate this many hours to do this. You can give them more detail in that estimate. They're going to know exactly what those charges are, how they're computed. They're going to say, usually, oh, okay, I understand where it's coming from. And if they don't like something, they'll know why and which part they want to cut out. It helps them narrow the request, saves you time and money in the long run. It's also just, yeah, it's good public relations. I mean, and that's an important part of FOIA that's not strictly written into the law. But the better your public relations are, the less problems you're going to have.
Say that again, it's on camera. Say it again.
Better public relations, less problems with FOIA, always. Especially get newspaper reporters on your side, and they'll write nice articles. The editors like you and know you handle things well and up front and in the open. They're going to write nice editorials usually, you know, that kind of thing. That's just the way it is. That doesn't mean you have to give them something that's exempt just because you want to be nice. You know, if it's exempt, you're allowed to withhold it. You know, just don't be rude about it. We see occasionally people do things, you know, and it's not even that what they're doing is wrong. They're allowed to do it, but it's the tone of their responses and the way they write things is just, you know, it leads to people butting heads when there's no good reason to fight. And that's one of the situations where we're happy to come in and help people and try to work things out. Any questions about charges? I'm trying to think. I think we covered just about everything with charges. So we can move from there. This is the fun transition. Going to move over to electronic records, emails, that kind of thing. So my first question, I want a copy of the 30-page report you've got sitting at your desk you've already printed off. How much do you charge me for it? Well, nothing, thank you. That's very nice. How much can you charge me for it? Well, however much it costs to copy.
Can't charge you money.
Yeah, your printing costs, basically. Sure. I want a copy of that report emailed to me, please. I know you've got an electronic version of it. Just attach it to an email. Here's my email address. You going to do it? Sure. How much you going to charge me? I like your first answer. Say it loud.
Nothing.
Nothing. Yeah. How much could you charge me for that email copy?
Manpower time.
Manpower time. However long it took you to hit, you know, attach.
Right.
Send.
You know, sometimes it can take you a real long time to
Yeah.
find electronic file.
Yeah, I mean, that's actually a very good point.
Yeah.
Because there are times when there are searches involved in electronic files. And a lot of people get confused, and this is where email comes into play a lot. I want every email back and forth between the dean and all of the board members for the last 6 months, especially concerning fundraising projects. Everything. How big a request is that?
Big request.
Big request. Okay. I only wanted about fundraising projects that involve individual donations over $100,000. How bigger or smaller? Search time?
Search time's larger, definitely. More queries to run, for sure.
Search time's larger. Yeah, and actual responses are smaller. Search time's larger. 6 years instead of 6 months. How long do you keep your email on your computer?
Every 3 months,
Every 3 months? Does it go to
Our
backup?
assistant administrator tells us, you're over the limit, you're ready.
So how far back can we go? I mean, you've got backup tapes probably.
Yeah, we got some archiving, probably a couple years, maybe.
Question?
You're going to email a document to just any email address?
Sure. Why not? Does it matter what email address it's sent to? Did everybody hear the question? It's any email address. Does it matter? Well, we'll go back to the beginning of this part. What's a public record?
Okay.
Something owned by,
Right.
prepared by, in the possession of, a public body, officers, employees, agents, in the transaction of public business.
Right.
Does it matter what email address it's on?
No.
Nope, not at all. That's one of the issues with email. Go ahead.
My concern about sending a digital file is the person receiving it can have modified.
Yes.
Yeah.
Yeah. And that is a concern that somebody can modify it. When they do so, there's laws outside of FOIA that usually make that a criminal act, depending on what they're doing, why they do it, what they do with it. So they get punished under those laws. If they misuse something and say, I am the dean, and I want to buy a new Porsche for the school, deliver it to my home address. Well, that's pretty clearly, perpetrating fraud. So. But yeah, depending on what people do, I mean, we've heard that concern, and so some people have said, well, can I only give them a PDF version because I know they can't modify the PDF easily? No, you can't do that.
You can't?
You cannot do that. You can't limit it. No, because FOIA specifically says you have to provide it in any medium, any format that you regularly use.
Well, if they don't
If
specify.
if they specify. So if I say, I want you to email me the Microsoft Word version of that, if you use Microsoft Word and you've got it on an electronic file, yeah, provide me the Microsoft Word version. Use Corel WordPerfect, I ask for that, you give me that version. One of the weird ones that still says under FOIA, well, if you can't, you can't. If you don't use it, you don't use it. If I say, hey, I really want that as an Excel spreadsheet, and you say, I'm sorry, we don't use Excel, we just don't have it. Well, you don't have it. You don't have to provide with something you just don't have, or that you just don't use.
Well, what if it is, let's say it is an Excel file, they want it in a Word file, is it up to me to convert it?
If you have the conversion capability, yeah.
It is?
Do it.
It is.
Yeah, and one of the things with a lot of these things also, even if you don't personally have it, especially with the state agency, college campus, somebody here probably can, most likely. And if not, there was a thing we were talking before about making a reasonable effort to agree on the production of records with the requester. Well, if it means going down to Kinko's and having something scanned or something like that, you can offer. You don't have to necessarily do it if it's something beyond your internal capabilities, but you can offer, but make sure they understand you're going to pass the cost along.
Sure.
Or you can offer, I can give it to you in Word format, and you can get it converted yourself.
Right.
Which most people like that latter option because it's cheapest. With email, there's a few other things. We're talking about the time on emails. A lot of people don't understand that once you hit, a year, 6 months, whatever it might be, you're usually talking about going into backup tapes. And backup tapes are not the same format as your standard email. Most of us cannot search backup tapes. We don't have the equipment. We don't have the software to do it. You got to go to the IT department. Now, how much are they paying? More. They're paying the IT guy's salary. They're not paying, that lowest common denominator or the person who works at the front desk. They're paying a computer professional who's, paid pretty good money usually. And all of a sudden, that's the actual cost because that's what it actually takes to search those backup tapes. How much searching is involved? A lot. Hours. Thousands upon thousands of emails usually. So those costs go up really fast. And we've seen that. And it's best, do everything you can to minimize it. Because you always want to minimize the cost to you and to them. But be realistic and explain that, again, about the estimate. Tell them, this is why. Because I've had people say, I asked for 6 months worth of email. I didn't think it'd be that much. And they gave me an estimate for $2,000. What's that? Where is that coming from? And we start talking, well, did they have to go to backup tapes? What do you mean? I don't know. They didn't say. They just said $2,000. Public relations.
Right.
Good detailed estimate. Very important. With email, there's a few other things to keep in mind. One of the documents you have there is the one actually, could you hold that up? Just for everybody to see. Email use, access, and retention. That was done in conjunction with the Library of Virginia. Remember I talked a little bit about the Public Records Act earlier and the retention schedule. So that one talks a little bit about keeping your email, retaining it, how long you have to do it, as well as the fact that email is a public record if it's talking about public business. You know, again, it means it's the same definition. We saw, and this is common for a lot of times localities, boards of supervisors, city and town councils, that kind of thing, planning commissions, where people ask for their email. And a lot of those people, you know, they have a job. That's private business. They have a home. They live there. And they have a computer there. They have a computer at work. They might have a laptop issued by the government. They might not. They'll probably have a government-issued email account, a work-issued email account. If they're like most people, anywhere from 1 to 5 personal email accounts that they're using for different stuff. Which of those is subject to FOIA? Whichever one has public records on it. It might just be all of them. So when somebody makes that FOIA request, do they have to search all of them? Yeah, sure, if that's the way they're doing it. One of the things we've seen, I think it was Fredericksburg City Council had a request like that where, in my understanding, it was before I worked for the council, but it was a big mess. It took months of searching to sort out because people had their emails all, you know, here's one on my desktop, there's some on this laptop, this is my government account, that's my home account. Oh, forgot the ones at work. I kept a file over there that I was working on late one night. So, you know, you see this in different places. You have to search all the different things. It's a real pain. There's a pretty easy solution that they've implemented there. Every time they send or receive an email that's about public business, carbon copy a copy to the clerk. Send it off to their clerk. Their clerk has a copy of every email dealing with public business from every council member. That request comes in now. I've got it. I'm the clerk. I've got it. And it's only the clerk has to search and they know what's in there. And they said, actually, we talked to them, they said they're training, you know, every time a new councilman comes in, they train them, and every one of them is, okay, no problem, the system works. So, you know, that's something to consider, depending on, especially for the higher level officials, chief, dean, that kind of thing. You might want to run off copies of a lot of this stuff, especially if it's something you know people are interested in, you know a request is going to come in over a controversial issue or something, you might want to run off a copy just so people are ready for it. It applies more to people on boards, but it can't apply to everyone. Do y'all have a college president?
Yes.
Okay. One exception to this rule is for the college president. They have the exemption for working papers and correspondence, which would include their email. It's not going to include anybody else, though. It's just the president. Specifically, it is 2.2-3705.7, number 2.
What is this again?
This is the exemption for working papers and correspondence. Generally, it's kind of like executive privilege. So in the university context, it's college presidents. Let me go ahead and read it to you. Working papers and correspondence, the office of the governor, lieutenant governor, attorney general, members of the General Assembly or Division of Legislative Services, mayor or chief executive officer of any political subdivision of the Commonwealth, or the president or other chief executive officer of any public institution of higher education in Virginia. So, working papers and correspondence. Working papers is defined as records prepared for or by the above-named public official for its personal or deliberative use. The basic idea there is, you know, the executive decision-making process can be done privately, including their correspondence and working papers. With working papers, if they then start giving that out to other people, for example, the college president shares that with the board, that waives the exemption because it's no longer for personal or deliberative use. Correspondence, however, I've only ever seen one case, and I think it was a circuit case. The court basically said, well, correspondence is not defined in the statute, so you go to the common usage, letters, emails, all that stuff. And it's not limited to personal or deliberative use. It's whatever he's sending back and forth, whatever he receives. So the college president does not have to release emails, but again, it's discretionary. Matters of controversy, a lot of times it's a good idea to go ahead and release it before you're sued. So that's just to throw that out there. One final, there's two other points. One is email at meetings, which we didn't really go into electronic meetings because nobody really deals with it. If the board uses email to communicate with each other, and it rises to the point where it looks like a simultaneous real-time communication, that can be considered an improper electronic meeting. There was a case the Virginia Supreme Court looked at in 2004 where they said an element of the definition of meeting is simultaneity, where everybody is sitting down at the table together, or electronically, they're still communicating all at the same time. They had a situation where people were worried about emails, and they looked at it, and in that case, they said the closest anything email was sent and response received was about 4.5 hours. I said that's not close enough for us to call it meeting. That's more like traditional correspondence through the mail with a letter or inter-office memos. It's still a public record, sure, but it's not a meeting. I would especially hesitate to have the board use anything like an instant messenger program, because if 3 or more of them are on instant messenger together, that's certainly going to look like a meeting. With email, the danger is if they're hitting, I want to list every member of the board as a group and send it to the whole group at once, and somebody hits CC or reply to all and sit back to the entire group. Well, if I send an email to the entire group, 2 members are also on their email at the same time. They get it. They hit their responses. They say, this is a great idea. And one of them goes, no, this is a terrible idea. And they send those off. Reply to all. Well, all of a sudden, we've got 3 people communicating in real time. That looks like a meeting. That could be problematic. We haven't actually seen the case saying what the limit is on time. We know 4.5 hours or more in between sending and responding is not going to be considered a meeting. We're not sure what the lesser time is. 5 minutes, is that a meeting? I don't know. Maybe, maybe not. It depends on the facts. There's also one final piece of advice regarding email. And this is not FOIA. This is just me acting like your mom. Every email you send, let me just ask you, has anybody ever received a joke in email?
Yes. Sure, yes.
Is anyone actually friends with any of your coworkers?
Yes.
Amazing, isn't it? Yeah. Anybody ever do anything on the weekend with a coworker that's not related to a school function? Say, hey, you want to go to a movie, go to a picnic, go bowling. That stuff we're talking about, where a lot of that isn't necessarily public business. It's not necessarily going to be subject to a FOIA request. It is in an email. How hard is it for you to forward an email to someone else? And the worse it is, how tempting is it for you to forward it to somebody else? The worse the content. Has anybody ever sent an email that you're not proud of? Don't answer that. I don't want to know. My final piece of advice on email, always keep it professional. Always read it as if you saw it on the front page of the New York Times the next day. Better yet, read it as if your mother was reading it on the front page of the local paper the very next day. With email, what else have we got? Exemptions is really the next bit. We talked about personnel records. Other general, well, let me just kind of, the breakdown on exemptions and kind of a theoretical view of it. As we said before, the basic idea, once you have a public record, it's presumed to be open unless it's exempt. There's really 2 kind of different situations. FOIA exemptions that you find within the Freedom of Information Act, and there's about 100, 110 of them for records. Those are almost all discretionary, where they say you may withhold this record in the discretion of the custodian. That also means you could give it out. If you go to my boss and say, I want to see a copy of Alan's resume because that talk he gave, I don't think he's a lawyer. No way. Well, if you do that, she can say, no, really, he's a lawyer. Here's his resume. What's my recourse if she does that? Nothing. There's nothing wrong with doing that. She can share it. It's a personnel record. She doesn't have to share it. She can say, no, I'm not going to give you that. I'll just tell you, yeah, he is. Okay? But she can share it. There's discretion. On the other hand, we talked about criminal history before. There's laws outside of FOIA that say if you give out a criminal history record improperly, it's a criminal misdemeanor. They can throw you in jail for doing that. Okay, that's a prohibition. That's a little bit different than the FOIA exemptions where you have discretion versus things that actually affirmatively prohibit. And we call a lot of those FOIA trumps because FOIA says, except as otherwise specified, you shall give out these records. Well, that's as otherwise specified. So if there's a law out there saying do not give this out, then don't give it out. Most common ones we deal with are going to be criminal history records, probably tax records. People's individual tax returns. They don't give those out generally. Let's see. There's also the idea of exemptions of general application versus more specific exemptions. Like I said, there's over 100 record exemptions in FOIA. Most of those are very specific, both as to the type of record and the agency that can use it. So you'll see, for example, there's some specific ones about the Medical College of Virginia, and they are a specific type of records as well. Could you use that exemption here at Thomas Nelson? No, it's specific to that college. On the other hand, there's scholastic records. That's an exemption of general application. If you got scholastic records, you can withhold them, basically. So with that one, you would withhold it. Personnel records, again, is general application. Another general application one is contract records. If you're in the process of negotiating a public contract, you can withhold records that would jeopardize your negotiating strategy or bargaining position before the contract's awarded. Once the contract's awarded, it's open. There are some other procurement laws out there where in certain situations you can withhold trade secrets, financial data of the third party, that sort of thing.
Can
But-
we,
go
I'm
ahead.
sorry, we had a request before questioning why a particular contract was awarded to a vendor.
Actually, that's a good point. They ask you why. Is that
Can we
FOIA?
provide that?
That's not FOIA.
That's not FOIA. Yeah, there's two big myths. We already dealt with one, but Freedom of Information Act. One, it's not free. You're allowed to charge. We already talked about that in some detail. But two, it's not about information. It is in the theoretical sense, but what it's really about is public records. Access to public meetings, access to public records. But it does not require you to answer a question or give an explanation. If someone says, hey, somebody told me you guys have a policy that you don't let lawyers talk in your classrooms. Well, why is that? That's not a FOIA request. If I say, somebody told me there's a policy that you don't let lawyers talk, can I have a copy of that? That's a FOIA request. So, always keep in mind and give people the benefit of the doubt, because most people aren't really strict about their phrasing when they make a request. And if they ask for something and you have that explanation in a record form, treat it as a FOIA request and provide the record. But if you don't have to create one. Yes?
The FOIA request have to be written.
No.
Can we tell them they have to write it?
No. We addressed that earlier. You do not. If you want it written, you can certainly write it down, but you cannot make a request to write it down. All they have to do is be a citizen or member of the news media, technically, and we talked about that. But
Citizen of where?
Commonwealth, which if you can tell me what that is, I'd love to know. That's a separate issue. But a citizen of the Commonwealth or a representative of the news media with broadcast and circulation of the Commonwealth, you're allowed to ask them for their name and legal address, and they must identify the records they want with reasonable specificity. Basically, again, that means you know what to look for. And if you've got something good to go on, you're pretty sure, but you're not quite sure, ask them. That's always the easiest thing. I've had so many people call me up sometimes and they say, we got this request in and I want to fax you the request in the exact language because it looks like this, but it could be this, and I have all these different records. I'm just not quite sure what they want. And I said, don't fax me the request. Call them. Talk to them. They know what they want. I don't. I'm not a mind reader. I'd love to help you interpret this stuff, but the first step, talk to the requester. That's also a good opportunity for good public relations. Say, hey, we have this, we have that, we have the other. Because a lot of times with the requester, they won't necessarily understand how you keep your files. They won't necessarily understand that, the law says you must have a status report on blah, 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 but you actually keep something else that you call an activity report that in reality is the status report, but you give it a different title. And that can really confuse people and throw them off. So if that's the situation, just talk to them and explain, this is what we have. What do you want? Handle it that way. Last little bit, we have about 5 minutes remaining. If there's more questions on records, I'm happy to talk about it, but I was going to talk about remedies. What do you do when something goes wrong?
Call you.
Yes. Yeah. Please do. Feel free to call me, and I'm going to encourage you to, like I just said, talk to the requester. And if you ever want a neutral party to help informally mediate, we don't have any formal powers. We don't investigate. We don't enforce FOIA. Only the court does that. But, we're happy to sit down and say, well, this is what the law says, and we think you should do this. And with the requester, this is what the law says. They're allowed to do that, or no, they shouldn't have done it that way. They should have done this. And the options are either we talk to them or you guys work it out among yourselves, or they sue you. That's the formal remedy in FOIA is a petition for mandamus or an injunction. Mandamus is when a court orders a public official to do something they are already required by law to do. Usually in FOIA, that's, I made a remembrance request, it's been 6 months and they never responded. Judge, please make them respond to my request. It doesn't necessarily mean they're going to order them to give the person the records, it just means you're going to be ordered to give a proper response to FOIA. With meetings, a lot of times it's, they've been holding closed meetings without announcing them to the public. They haven't been giving proper notice. Judge, please order them to give proper notice in the future. If the judge does it, well, there you go. That's the mandamus. Injunction is when the judge orders you not to do something. Judge, they keep charging me $50 an hour, and I know that person gets paid $15 an hour. They're overcharging me. Please help me. The judge says, yeah, that's right. You can't charge that. Pay them back this much money, and don't do it in the future. I enjoin you from doing it. So there's your injunction. The kind of the teeth in FOIA with that, if you lose, you will have to pay attorney's fees and court costs. That's what I was talking about with the cases earlier. I think the grand total is somewhere near $4,000 that the Department of Payment and Officials are supposed to pay the all rights for attorney's fees and court costs. There was something going around. It was pretty high at one point because he had 3 different suits that he won against them. If you win, you're not going to, you're going to leave court. You're still stuck with your own attorney's fees and court costs, most likely. But it says in FOIA that the court shall award attorney's fees and costs unless the award is unjust because of some sort of special circumstances. That's, again, fact by fact, case by case kind of basis for the court to decide if there are special circumstances. I'll tell you, there was a case against the Culpeper Board of Supervisors for improper use of the meetings exemption to discuss the contract. I'm not going to go into all the details because it's fairly complicated. But suffice to say, they lost. At the circuit court level, they had lost half their case and won half their case. They got up to the Supreme Court level and they lost on both points. At the circuit court level, they said, well, you all have been using the same meetings practice with these motions this is the point they lost on about how they do their meeting motion to close a meeting, and said you've been doing it the same way for years and you've corrected it since then, so I think this is special circumstances. We're not going to award a fee for this part of it. And this other one was inadvertent. We think you had legal justification somewhat, but you were wrong ultimately, but we think it's special circumstances. We're not going to award the fees and costs. The Supreme Court said no, they were doing it wrong. There's no special circumstances here. I believe they actually settled on the final amount of fees. This was a case that went from General District Court to Circuit Court to the Virginia Supreme Court, and the locality ended up paying, I believe it was $93,000 in fees and costs. Okay, that should scare everyone. All right? So, that can be very serious depending on how far you go in court with it if you lose. The other point about it, and this actually recently, someone was found to have knowingly and willfully violated FOIA, and I believe that case is on appeal now. I think it's on appeal right now. I think they're arguing it as we speak. But what the FOIA provision says, if you were found to have knowingly and willfully violated FOIA, they will charge you a civil fine that's paid to the State Literary Fund. I believe the initial account is $250 to $1,000, and then it's $500 to $2,500 for each second and subsequent violation of FOIA. And that comes out of your pocket. The public body does not pay it for you. That goes to the individual who is found to have